I want to start with the scenario that sounds a bit like a logic puzzle, but it's a very real legal problem. Let's say I own a huge plot of land with a lake on it.
Okay.
Now, I don't want to sell you the land. I don't even really want to lease it to you. But what I do want to do is sell you the exclusive right to catch fish in that lake and, take them away.
Right. A straightforward commercial deal.
Is it, though? Because my question is, what have I actually sold you? Is it a service? Is it just like a permission slip to come onto my land? Or have I actually transferred a piece of property?
And the fish move.
The fish move, exactly. How can I sell you a property right over something that might swim downstream 5 minutes later?
It's a great question to kick this off because it really forces us to define what property even is. I mean, most people think it's just dirt, bricks, a fence.
Yeah.
But in this scenario, which is a classic case under the Transfer of Property Act,
Hmm.
you are, believe it or not, creating a lease of immovable property.
See, that's where I get stuck. Immovable, the water moves, the fish swim. How is that immovable?
Because the law looks at the source, not the object itself. The Transfer of Property Act, specifically Section 3, it defines immovable property way more broadly than just soil. It includes benefits to arise out of land.
Benefits arising out of land.
Precisely. The fish are a natural product of that specific lake on that land. So by selling the right to catch and carry them away, you're transferring a benefit that's inherent to that immovable land. It's not just a permission slip, it's an actual interest in the property.
That distinction is so important, isn't it, between a permission slip and an interest? I'm thinking of another case we looked at about toddy tapping.
Right, problem 14 in our stack, extracting sap from palm trees.
In that case, someone got the right to tap the trees, but they couldn't cut the leaves or really control the grove, and the court said that wasn't a lease, it was just a license.
Correct. And the key difference is exclusive possession. With the fish, you generally have an exclusive right to that benefit. In the toddy tapping case, the person just had permission to use the trees while the owner kept control. A license is personal. I let you do this. A lease is a property right. You own this.
It's just wild that we're still using a law from 1882 to figure this all out. The Transfer of Property Act, it sounds so dusty and, frankly, dry.
It is Victorian, no doubt, but dry. I'd argue it's actually a study in human psychology disguised as legislation.
How do you mean?
Because property law is where human nature clashes with economics. You get greed, the desire to control your kids from beyond the grave. You get fraud, people trying to be clever. The Act of 1882 is just the referee stepping in to say, okay, here's the line between being smart and being a cheat.
Well, let's talk about that line, specifically with greed and inheritance. We have a scenario here. Let's call it the greedy heir. So you have a father and his daughter. The daughter needs cash. She goes to her dad and says, look, I'm going to inherit your property one day. Give me 5,000 rupees now, and I'll sign a deed releasing my right to inherit later.
Cashing out early. It's a common impulse.
Exactly. So the father agrees. She takes the money, signs the release. Years later, he dies. The daughter shows up and says, right, I'm here for my inheritance.
And the family says, no way you sign this.
But the court sides with the daughter. She gets the money and the inheritance.
She does. And I know you're thinking, that feels like a scam. She double-dipped.
It feels illegal. She signed a contract. She took money for it. Why does the law let her get away with that?
It all comes down to what was actually transferred,
Hmm.
or what wasn't. You cannot transfer something that doesn't exist yet. This is the whole doctrine of spes successionis.
Which is Latin for hope of succession.
Roughly, yes. Section 6A is absolutely brutal on this. It says the chance of an heir succeeding to an estate cannot be transferred. When she signed that deed, she didn't own the property. She didn't even own a future right to it. All she owned was a hope.
Because the father could have just sold everything before he died.
Exactly. Or left it all to a cat charity in his will. Until he takes his last breath, her so-called right is just a statistical probability. The law says you can't sell a probability. It's like trying to sell me tomorrow's winning lottery ticket today. Even if you win, our deal was void from the start.
So the contract was void from the beginning. Ab initio.
Precisely. And there's a public policy reason for it, too. The law wants to protect heirs from being preyed upon by, say, moneylenders who might buy up their future inheritance for pennies on the dollar.
That makes a lot of sense. It saves people from their own desperation. Okay, so that's about acquiring property. Let's flip it and talk about controlling it. This is where that human nature thing really comes out.
The dead hand problem.
Right, and we see it in these unborn person scenarios. This stuff gets complicated. Let's take problem 4. A man transfers property to his son, let's call him P, for his life. Then, after P dies, it goes to P's unborn son.
All standard estate planning so far.
But here's the twist. The unborn son also only gets it for life, and then it has to go to someone else, R. The court says the whole thing fails. Why?
It fails because of Section 13. This is a rule designed to stop what we call perpetuities, basically tying up land in a family forever so no one can ever actually sell it.
But why does the for life part kill the deal? Why can't I give my unborn grandson a life interest?
Because the law demands that if you're transferring to an unborn person, you have to give them the whole remaining interest in the property. You can use a living person like the son, P, as a kind of placeholder for a while.
Yeah.
But the second it lands with that next generation, the one that doesn't exist yet, it has to vest completely.
So you can't just keep passing the baton down the line forever. Someone has to actually catch it and own it outright.
You've got it. Think about the economics. If I could say, to my son for life, then his son for life, and so on, I could lock that land up for 100 years. It could never be sold, never developed. It's basically feudalism. The law steps in and says, no, you can control the next step, but once it hits that unborn beneficiary, they get everything, full stop.
And this connects to the age restriction too, right? Problem 5. A transfer to an unborn son when he turns 25.
Also invalid.
Because of the age.
Yep. That's Section 14, the rule against perpetuity. You can only postpone the ownership vesting for the life of living people plus the minority of the unborn child. In India, the age of majority is 18. By saying when he turns 25, you're delaying it 7 years too long.
You're trying to control him from the grave for too long.
That's it. The law is basically saying, we will tolerate your control for 1 generation plus a childhood. After that, let the living rule the world.
I like that. Let the living rule the world. But what happens when the living try to control other living people? Let's move to these conditions.
Sections 10 and 11.
Yeah. So the scenario is, I sell you my house, done deal, but in the fine print I write, the buyer must reside in this house. I didn't rent it to you, I sold it to you, but I'm telling you where you have to live.
And that condition is totally void. You get the house, and you can just ignore it.
But why? If I agreed to it, signed the deed, why isn't that binding?
Because the very definition of ownership includes the right to alienate, to transfer it, lease it, or even just leave it empty. Section 10 says that a condition that absolutely restrains you from disposing of your interest is void. If I sell you a house but then take away your right to decide how to use it, did I really sell you the house?
It's repugnant to the interest created.
That's the legal phrase. You can't give with one hand and take away the essential parts with the other.
So what if the condition isn't about the house, but about my personal life? We have problem 6 here, where an uncle transfers money to his niece, but only on the condition that she deserts her husband.
And this is where we move from economic policy to, well, public policy, Section 25.
And the transfer is void, obviously.
Yes, but specifically because the condition is immoral or opposed to public policy. The law sees marriage as a foundational social institution. So a contract that offers a financial reward for breaking up a marriage is considered harmful to society.
It's interesting the law has a moral compass there. It won't be used as a tool to incentivize what it considers home wrecking.
It has to. The courts can't be used to enforce immorality. But, and this is a very big but, the law's definition of what's immoral or unfair might not always line up with yours.
I have a feeling you're leading us to the coal mine.
I am.
This is problem 12 in our stack, and I have to say, this is the one that bothered me the most.
Usually is.
Okay, set the scene. I'm buying a piece of land from you. I've done my homework. I'm a geologist or have inside info, and I know there's a massive coal vein under your field. You, the seller, have no idea. You think it's just a pasture?
Total asymmetry of information.
I buy the land from you for the price of a pasture pennies on the dollar. I don't say a single word about the coal. A month later, I start mining and become a millionaire. You sue me, saying I cheated you by staying silent.
And under Section 55 of the Act, you, the buyer, win. You keep the coal. You owe the seller nothing more.
How is that not fraud? I knew the value was astronomically higher. I deliberately withheld that information to get a better price. That just feels like theft.
I get the moral outrage. I really do. But the law draws a very, very sharp line here between what it calls latent defects and latent advantages.
Okay, break that down for me.
If I am the seller, I have a duty to tell you about defects. If the title is bad, if there's a huge crack in the foundation I know about. But if I am the buyer, I have absolutely no duty to disclose things that might increase the property's value.
But why not?
It's a version of caveat venditor. let the seller beware. But in this context, it's about the seller knowing the value of their own asset. If the law forced buyers to disclose every potential upside they see, it would paralyze commerce. Think about a stock trader having to tell a seller, by the way, I think the stock's about to go up because of my research.
So the law is rewarding due diligence. I put in the work to find the coal, so I shouldn't have to just hand that value over to you.
That's the logic. Unless there's a special fiduciary relationship, like if I was your lawyer or your agent, it's an arm's-length transaction. You are responsible for knowing what you own. I am not responsible for educating you about it.
It's brutal. It puts the entire burden on the owner.
It is. But think of the alternative. If a sale could be overturned because the buyer knew something the seller didn't, every single transaction would be at risk of litigation years later. You knew this neighborhood would get trendy and you didn't tell me. The law has to prioritize the certainty of the sale over the seller's later regret.
Certainty. That seems to be a theme here. We see it with the coal mine, and we see it in this fake owner scenario problem 8.
The doctrine of the ostensible owner. Section 41.
Right. This is where Ramya owns land, but lets Soumya put her name on the deed, lets her act like the owner. Then Soumya sells it to an innocent buyer, Sanjana. Ramya comes back and says, wait, that was actually mine the whole time.
And Ramya loses, because she's the one who allowed the deception to happen in the first place.
So here, the law punishes the person who made the fraud possible.
Exactly. When you have two innocent people, the duped real owner and the innocent buyer, the law protects the buyer. Why? Because Ramya was the one who enabled the fraud by letting someone else masquerade as the owner. The law protects the good faith purchaser for value.
Good faith. That's the key. Sanjana checked the records, saw Soumya's name, and paid her money. She did everything right.
Precisely. If we didn't protect Sanjana in that situation, nobody would ever feel safe buying property. You'd always be worried about some secret owner popping out of the woodwork.
But the law doesn't protect every buyer, does it? There's the issue of lis pendens.
Problem 9. And this is where the buyer isn't protected because the timing is very suspicious.
This is where I'm being sued over the title to my house. The lawsuit is active, it's pending, and I realize I might lose, so I quickly sell the house to a friend to try and mess up the judgment.
And Section 52 says, not so fast. Lis pendens just means pending suit. The rule is that during litigation, nothing new can be introduced. You cannot transfer the property to a third party to defeat the court's eventual decree.
So the buyer, my friend, in this case, is stuck with whatever the court decides.
Yes, even if your friend had no idea about the lawsuit.
Wait, even if they didn't know? That seems to contradict the innocent buyer protection we were just talking about.
It does seem like a contradiction, doesn't it? But here, the authority of the court is seen as more important than the innocence of the buyer. If people could just sell property mid-lawsuit, court judgments would become meaningless. You just keep selling land to new people, and the plaintiff would have to start a new lawsuit every single time. It would be chaos.
So if you're buying land, check for coal, check for fake owners, and check for pending lawsuits.
Check everything.
There's one last one I want to touch on because it deals with, well, indecision, or maybe just trying to have your cake and eat it too. The doctrine of election.
Problem 7. This is a fascinating bit of legal logic.
The scenario is this. A father leaves a will. In it, he gives me, his son, a pile of cash, let's say 25,000 rupees. But in the very same will, he gives my favorite ancestral house, which actually belongs to me, not him, to my sister.
Right. So he's giving away his own money, but he's also trying to give away your property.
So my first thought is, great, I'll take the 25,000, thank you very much. But the house is already mine, so I'm obviously keeping that too. I want both.
And Section 35 stops you cold. It says you have to elect. You have to choose. You can either accept the will in its entirety or you reject it in its entirety.
I can't cherry pick the good parts.
No. The principle is that you can't accept the benefit of a document while rejecting the burden it imposes. The father's intention was a package deal. If you want his 25,000, you have to go along with the transfer of your house to your sister.
And if I choose to keep my house?
Then you forfeit the 25,000. Under Indian law, if you reject it, you give up the benefit entirely. That money usually goes back into the estate to compensate your disappointed sister.
It really forces you to show your hand. You just can't game the system.
And that's really the summary of the entire act, isn't it?
It feels like it is. Looking back at all of these scenarios, from the fish to the coal mine to the unborn child, it feels like the Transfer of Property Act is trying to balance two contradictory forces.
What's the main conflict you see?
Well, on one hand, the law loves freedom. It wants property to be free to move, free to be sold. It strikes down those "you must live here" rules and the unborn traps that keep land tied up.
Alienation. The law favors the free alienation of property.
But on the other hand, it is obsessed with rules. It demands these precise definitions for fish, it demands you make a choice, and it demands you bear the risk of your own ignorance, like with the coal mine.
It's a balance between liquidity and certainty. The economy needs liquidity. Property has to change hands to find its highest value, like with the coal mine. But society needs certainty. We have to know who owns what, so we don't have endless fights over inheritances and secret owners.
And sometimes that search for certainty leaves a bad taste in your mouth. I'm still not over the coal mine ruling.
It's the one that always lingers. It's a reminder that legal and fair are not always the same thing. The law provides a framework for the market to operate, not a guarantee of cosmic justice.
Caveat venditor.
Let the seller beware.
Well, on that slightly ominous note, we're going to wrap up this deep dive into the Transfer of Property Act. Whether you're leasing a lake or writing a will for your unborn great-grandson, read the fine print.
And maybe hire a geologist.
Definitely hire a geologist. Thanks for listening, and we'll catch you on the next deep dive.